Hello, everyone. My name is Brandon Magner. I'd like to extend thanks to Dominic and the rest of the Journal for inviting me today. Like the other government employees who spoke today, I'm going to offer the same disclaimers. My views are my own. They do not represent those of the agency I work for, the National Labor Relations Board, the union I'm a part of, the National Labor Relations Board Union, or I guess the United States government. So today I want to talk about remedies under the National Labor Relations Act. As interpreted by the Supreme Court, the NLRA is remedial in nature, not punitive. So while Congress recently considered empowering the NLRB to issue fines for unfair labor practices in the reconciliation process, the agency is still without that power. And as virtually all research on labor law has shown, the Act today fails to deter even routine violations. And remedies are kind of the white whale of labor law. It's the NLRB is, at the end of the day, a law enforcement statute or a law enforcement agency. And so its merits must be evaluated by if it's able to enforce the law that it's set to enforce. And while I find my work deeply rewarding and really enjoy my time as a board agent, there's few things that are more frustrating when you're calling a charging party and you're telling them that a regional director has found merits to their case, and they're asking you, what does that mean? What am I going to get out of this case for the violations of federal law that have been imposed upon me? And you tell them, well, we're going to post a piece of paper on a wall saying that the law exists, that of whose rights that you were violated for. And then I had to convince them not to stop participating in the case and try and get a settlement. So despite this, the board has always possessed one potent remedial weapon since the beginning of the Act, and that's the bargaining order. So what's a bargaining order? It's the traditional remedy, standard remedy for Section 885 violations of the Act, and it's exactly what it sounds like. It's an order for an employer to bargain with a union after failing to do so previously in good faith. But where it is deployed in cases where a union has not been certified by the board, it's the most powerful weapon the agency has at its disposal to compel compliance with the Act's requirements. And this is because the bargaining order deprives an offending employer of the non-union workplace that it sought to preserve through its unlawful conduct. Early in the board's history, the Supreme Court made clear that the board was within its power to order employers to bargain with the union that had not been certified by the board under Section 9 of the Act, in a 1944 decision called Frank Brothers v. NLRB. In that case, the charging party union obtained signed cards from 45 of the 80 employees working in the employer's factory and requested recognition in bargaining. After its overtures were denied, the union filed a petition with the NLRB for an election. The employer subsequently engaged in what the Supreme Court called an aggressive anti-union campaign, which included threats of plant closure if the union won the election. The union withdrew its election petition and instead filed unfair labor practice charges, which resulted in the board issuing a complaint against the employer alleging an unlawful refusal to bargain. In challenging the appropriateness of the proposed bargaining order remedy, the employer proffered evidence that in the year and some change that had passed since the election petition was filed, the union no longer possessed a majority of the workforce because 13 of the original 45 supporters no longer worked for the employer. And the employer asked for an election instead as the remedy. The Supreme Court, in a unanimous opinion written by Justice Hugo Black, rejected the employer's argument and enforced the board's order. And I want to quote from that case because it's, I think, a pretty powerful passage, or at least seems out of place in how the courts today view labor law. He said, "It is for the board, not the courts, to determine how the effect of prior unfair labor practices may be expunged. The determination the board has made in this case and in similar cases is to adopt a form of remedy which requires that an employer to bargain exclusively with a particular union, which has represented a majority of the employees at the time of the wrongful refusal to bargain, despite the union's subsequent failure to retain its majority." And this part's key. The board might well think that, were it not to adopt this type of remedy, but instead order elections upon every claim that a shift in union membership had occurred during proceedings occasioned by an employer's wrongful refusal to bargain. Recalcitrant employers might be able, by continued opposition to union membership indefinitely, to postpone performance of their statutory obligation. In the board's view, procedural delays, necessary fairly to determine charges of unfair labor practices, might in this way be made the occasion for further procedural delays in occasion with repeated requests for elections, thus providing employers a chance to profit from a stubborn refusal to abide by the law. That the board was within its statutory authority in adopting the remedy which it has adopted to foreclose the probability of such frustrations of the Act seems too plain for anything but statement. So that passage is notable in two respects, in my opinion. One, the high praise of the Supreme Court's deference to the high praise from the Supreme Court in its deference to the board's industrial expertise. You do not see passages like that, unfortunately, today in courts reviewing board orders. And two, this passage is very important because it means the board was not confined to ordering only reruns of elections that or first runs of elections that employers were deemed to have tainted. So I just want to put a pin in that for later. After the Frank Brothers case, the board had to articulate a standard for when it would apply a bargaining order to remedy an employer's unlawful conduct after a union had requested recognition but not achieved certification. Given this was a Section 885 remedy, or Section 85 remedy at the time under the Wagner Act, the board naturally stuck with the concept of good faith when analyzing an employer's conduct. In a 1949 case called Joyce Silk Mills, the board stated that it would order an employer to recognize and bargain with the labor union if the union represented a majority of the employees in an appropriate bargaining unit at the time it requested recognition, and the employer denied the request while lacking a good faith doubt as to the union's majority status, and took action calculated to dissipate that majority status. So this basically began the concept of the modern organizing scenario where the organizer comes into the workplace, he slaps the cards down at the table and says, we have a majority of the workplace and we demand recognition. And that's been the model that's continued since then. And under Joyce Silk, thus any unfair labor practice which evidenced an employer's intent to destroy the union's majority could serve as means for a bargaining order. And that good faith doubt test controlled the board's treatment of these cases for the next 20 years. And while Joyce Silk intuitively applied in many instances, it eventually came under sustained criticism from the courts and practitioners in the late 1960s. The most common critique was that the employer's mindset at the time it denied a union's request for recognition was not as easy to measure as the board made it seem. It was said that an employer could in good faith suspect a union did not in fact have majority support of the proposed bargaining unit and later commit unfair labor practices for unrelated reasons, or even to prevent the union from in fact obtaining a majority support. How true that is, I have some doubts, but so Joyce Silk's good faith doubt test was abandoned by the board in 1969. And there's a very interesting story as to how that came to be, which I don't have time to get into today, but I encourage anyone who's interested in reading about that. There's a good chapter in a book called Labor Law Stories written by several labor law professors. But what's important for our purposes is that in oral argument for a seminal case called NLRB v. Gissel Packing, the board's attorney stated that it no longer looked to an employer's good faith doubt in deciding whether to issue a bargaining order. The new standard, accepted by the Supreme Court, was that the board would only issue bargaining orders where an employer's unlawful conduct is so outrageous and pervasive so as to make the holding of a fair election impossible. That means the focus changed from an employer's mindset at the time it refused recognition to the future effect of its conduct on the employees when they hypothetically would be voting again for a union. So this significantly raised the standard for what employer conduct would garner a bargaining order. The circuit courts applying Gissel would describe the standard immediately as an extraordinary remedy requiring evidence of hallmark unfair labor practices, such as discharge of union supporters or threats of plant closure. In practice, agency prosecutors would come to realize that it needed multiple of these ULPs to even sniff the chance at a Gissel bargaining order. And even then, that might not be enough. So if the aim was to preserve the Act's remedial powers in Gissel, then by any stretch of the imagination, the shift to Gissel was a tremendous failure for the board. Research shows that the board applied Gissel bargaining orders far less than it did Joyce Silk bargaining orders, and the courts are even more skeptical of it. Because the standard for its application was that a fair running or rerunning of an election must be impossible, courts further considered factors like the amount of time that had passed since the ULPs were committed and the amount of turnover in the affected workplace, as those could be reasons to run an election rather than impose a union upon employees that had largely not even voted or signed cards in the first place. Perversely, this actually incentivized employers to engage in many procedural delays as possible. So compare that to the passage from Frank Brothers where they identified that as the primary evil that the board was supposed to be eradicating. While many general counsels have since grappled with these difficulties of the Gissel regime, mostly by prioritizing interim relief through the issuing of Section 10-day injunctions, which, side note, that presents its own problems for the agency in rushing to federal court. It wasn't until recently that the GC's office finally labeled Gissel a failure. In a case called Cemex, where the NLRB's Phoenix Regional Office asked for and was denied a Gissel bargaining order, despite the ALJ finding the employer to have committed what he considered to be serious ULPs, including the discharge of a lead union supporter and numerous threats of plant closure. The General Counsel, on exceptions to the board in 2022, argued that Gissel has failed to deter employers from interfering with the board's election process, and its ineffectiveness is inherent in its formulation. Instead, the GC asked for the board to return to the Joy-Silk standard for issuing bargain orders, which he argued offered superior deterrence of violations to Gissel. Now, spoiler, we didn't return to Joy-Silk. As anyone who's read the decision will know, the board did not return to Joy-Silk standard in Cemex. Instead, the board forged a new path entirely. The Cemex decision, issued in August of last year, is a watershed decision for the board and the NLRA in many respects, especially in its overhauling of the board's representation case procedures. I'm just going to focus here, though, on the standard the board applied to the issuing of remedial bargaining order, although there's many other aspects of the case that are controversial. Specifically, the issuing of a bargaining order where a petition for an election had been filed. In Cemex, the board said it would no longer look to whether the running of an election would be impossible, as it did in Gissel. Rather, the board would now dismiss an election petition and issue a bargaining order in any case where the employer committed an unfair labor practice that, under the board's precedent, would require rerunning the election. So I think all labor lawyers immediately on that day realized this was a seismic change in the law. In the context of objections filed by a union to the results of an election, virtually any unfair labor practice committed by the employer will result in the rerunning of an election. And under election law, the R case proceedings, which are the board's election procedures, versus the C case procedures, which is the ULP context. In the R case, an unfair labor practice isn't even necessary to overturn an election. All you have to do is show that the laboratory conditions of an election have been violated. So the board explained that the new standard will promote a fair election environment by more effectively disincentivizing employers from committing unfair labor practices. I think that understates it. Cemex may come close, or as close as possible under board law, to completely disincentivizing employers from committing unfair labor practices in the critical period leading up to an election. In November 2023, the General Counsel issued a memo which detailed her interpretation of Cemex. And she had to do that because she had previously asked for Joy-Silk, so now she needed to give her interpretation of what the board had just done. In it, the General Counsel confirmed that she would seek a bargaining order as a remedy in any case where an employer committed a violation of Section 8A3 of the Act during a pending petition for election. And as for violations of Section 8A1, that could also garner a Cemex bargaining order unless the violations are so minimal or isolated that it is virtually impossible to conclude that the misconduct could have affected the election results. In evaluating whether a violation was sufficiently minimal or isolated, the General Counsel stated that she will consider factors such as the number of violations, their severity, the extent of dissemination, the size of the unit, the closeness to the election if one was held, the proximity of the misconduct to the election date, and the number of unit employees affected. And since Cemex was decided last year, there have been 2 ALJ decisions that have so far resulted in Cemex bargaining orders, just to show how they've been applied. In one case called INSA, Inc., the judge ordered a Cemex bargaining order where the union has signed authorization cards from 20 of 28 employees in the unit. The employer rejected the union's request for recognition, and the employer proceeded to discriminatorily discharge 2 vocal union supporters weeks after the union petitioned for an election, which it had subsequently lost. In another case called Big Green, the judge ordered a Cemex bargaining order where the union had signed authorization cards for a majority of the unit. The employer refused the request for recognition, and the employer coercively interrogated multiple employees, discriminatorily disciplined and suspended the union supporter, and discriminatorily eliminated bargaining union positions. So the caveat is that under Cemex, neither of these cases logistically are that difficult because they both featured hallmark unfair labor practices, so these would have probably gotten serious consideration under Gissel already. But the tougher cases will be what the General Counsel and the board do with only 8A1 violations alleged in the complaints, things such as just supervisor statements or unlawful work rules. As can be expected, Cemex has produced spirited debate amongst the labor bar. The company in the case has since motioned the board for reconsideration of this decision, which was denied, and they've appealed it to the Ninth Circuit, and the case is currently being briefed there as we speak. So CEMEX has created a lot of questions, and frankly, they will remain unanswered until the board further applies and explores the doctrine. Many of those questions revolve around CEMEX's unique blending of the board's election and unfair labor practice procedures, specifically its tethering of what would merit a bargaining order to the standard for a rerun election. There's also obviously the matter of the 2024 election and what the courts are going to think of CEMEX. Both could answer those questions. Both of those could resolve the case and the doctrine before we even get to further articulated standards. But whatever path CEMEX takes, I believe the decision proved that the board is still capable of innovation almost 90 years into its existence. While the board is frequently criticized for merely pinging and ponging between two competing interpretations of the law every 4 or 8 years, no one in the labor law community saw the CEMEX doctrine coming. I would argue that any bargaining order standard must be evaluated first against the Supreme Court's logic in the Frank Brothers case. In CEMEX, the board appears to have taken its duty to fashion legitimate remedies for unfair labor practices very seriously. Thank you.